Right, as I mentioned yesterday, the U.S. Supreme Court delivering a 6-3 ruling redefining the meaning of the word sex in Title VII of federal law, as employment law. Now, the implications of this could be quite significant for the future of religious freedom in terms of religious business owners, churches, schools, nonprofits, you name it. Joining me now to talk about the possible implications of the ruling is Senator Josh Hawley of Missouri. He is a member of the Senate Judiciary Committee, which is the committee that vets judicial nominees. Senator, welcome back to the program.
Thanks so much for having me.
Senator, I listened to your speech this afternoon on the Senate floor, and I'll have to say it was one of the most direct speeches that I've heard on the floor, calling out your colleagues, calling out legislators who sit back and allow the courts to rule on these things and basically legislate from the bench because lawmakers don't want to do it. They don't want to be held accountable.
Yeah, but the sad truth is, Tony, that almost all of the laws in this country are made either by unelected bureaucrats over in the agencies or they're made by courts. And let's not beat around the bush. What the Supreme Court did yesterday is legislation. I mean, they rewrote Title VII of the 1964 Civil Rights Act. They changed its terms. They changed its scope. They changed its application. And we know it's legislation because Congress has considered doing exactly what the Supreme Court did yesterday. Congress has considered doing that and has decided not to on multiple occasions over the decades. So this was straight-up legislation. And the truth is that that's not what our Constitution envisions. That's not our constitutional order, and this is something that has to change.
So, Senator Hawley, why is this ruling so significant?
Well, for a couple of reasons. I mean, the first thing is that by inserting effectively the term sexual orientation and gender identity into Title VII, it radically changes the scope and application of that title. This could have effects from everything. It will certainly have effects in employment law. That's obvious. These are employment cases that were up before the court. Likely to have effects in sports, school athletics, other forms of athletics under Title IX, because anywhere the term sex now is used in the 1964 Civil Rights Act and its follow-on statutes, it's now been effectively changed by the U.S. Supreme Court. So it doesn't just affect that one section of this one statute. It affects everywhere. And so certainly I think you'll see effects in sports and athletics, major questions there, major questions for churches and for church schools and for church charities and religious organizations. Their status now, their ability to hire or not according to their faith, their ability to require folks to adhere to behavioral standards according to scriptural tradition or the traditions of their faith, that is very much now up in the air. And the Supreme Court admits that, Tony. In the opinion, they say, yeah, these are important and open questions, and they'll be the subject of future cases.
I read that, and that was concerning to me because it was like they lit a fire alongside the road and said, you know, whether or not this turns into a roaring blaze that will consume everything in its path is yet to be decided. But we're going to light the fire today anyway.
Yeah, and stand back and watch and see what happens. I mean, it is no comfort to religious believers of any kind or any persuasion to hear the Supreme Court say, yeah, you know, your ability to conduct your ministry and your church, your synagogue, it may be completely upended. We'll just have to find out later. And, Tony, this is why courts don't legislate, is because they're not supposed to anyway. It's because legislatures can gather evidence, have full hearings, where it can write the bill in a very specific way. But that's not what the court did. The court adopted a sweeping rewrite of the statute, and now we're stuck with it. And this is what I was saying today. This part of this is the way we've gotten here as religious conservatives, evangelicals, conservative Catholics, conservative Jews, religious conservatives have been asked for too long now to basically be the silent partners in the legal conservative coalition. We've been told that, listen, you just be quiet, you supply the votes when it's needed, you do as you're asked to do, and maybe you'll get some judges who will protect your constitutional rights. Well, that's clearly not happening. And it's time that we change the bargain.
Yeah, I've been in this post for nearly 2 decades, and that play has been run multiple times, and the outcome has been similar in almost every case. And you made that point on the Senate floor today that, you know, I think we've come to a point where, look, these judicial nominees, and I know you were criticized for this because you were asking questions of a judicial nominee. In fact, you had people, I would say, of the same persuasion, conservatives. I wouldn't necessarily say in your own party, but they were conservatives who were going to run ads against you because you brought this issue up in just asking questions, which is, quite frankly, what you're supposed to do. We defended you, had you on the radio program talking about that. That's how we've gotten here, is that we don't ask those probing questions, and I believe we should. And this should prove this once and for all, that those hard questions have to be asked.
Well, we can't be in this posture of just, oh, hey, trust me, just listening to the same old people saying, trust me, just, we got this. Don't look too hard. Don't ask too, don't rock the boat. I mean, that's what the establishment has said to religious conservatives for years. I mean, for decades.
Yeah.
You're exactly right, Tony. I mean, it's decades now that we have seen this, and we have been told this, and we've been told, listen, you keep your concerns to yourself. You shut up and go along with this process. And in the end, maybe you'll get something out of it. By the way, the something that we're supposed to get out of it is what all Americans should get out of judging, and that is fair application of the Constitution of the United States. Religious conservatives don't want special favors. We want our First Amendment rights, and those for all people to be protected, and we need to start insisting on that.
Yes. In fact, Professor Robbie George, Princeton University, former member of our board at FRC, he put out a statement in part that said this, quote, "The tragedy of the Bostock is that despite Justice Gorsuch's desire to practice an authentic textualism, he failed to provide that, just as previous Republican appointees, Sandra Day O'Connor, Anthony Kennedy, and David Souter, so often and often spectacularly failed to provide it. Such failures always wound the rule of law. Coming on top of so many other cases in recent decades, this one may finally discredit it in the eyes of many who have struggled to retain their faith in it," end quote. Do you agree with Professor George?
Oh, I think he's exactly right, and I think it really, for religious conservatives, people of faith who have labored here in the vineyard, so to speak, I think that this result, it really is going to cause people to question. What is it we've been doing? I mean, what is it we have been working toward? If this is always the result at the end of the day, we have got to do better than this. And that's why I think I'm ultimately hopeful, Tony, about the future, because I think that what's going to happen out of this is religious conservatives of all persuasions and of all faith backgrounds who belong to that coalition are going to stand up and say, we're not going to be quiet anymore. We are going to put forward our ideas. We're going to raise our voices. We're not going to just be content to be relegated to the back. We're going to come up to the front now and lead, and that would be a good thing for this movement, for the country.
Yes, I could not agree more, Senator Hawley. And I want to go back and I want to underscore for our listeners and for those who are listening who are not necessarily with us, that we're not looking for justices that would legislate from the bench in the way that we want. We're actually content with the process by which laws are passed in this country. We simply want those on the courts that will adhere to the Constitution and the true meaning of words. This is, to me, Senator, this is very dangerous when you can change the definition of words 40 years later, because that means we have no foundation to stand on. If we can change the language, we can change the words through the very laws that we agree to be governed by, we have a really, really big problem.
Well, there's almost no point in writing down the laws. I mean, we may as well just let the justices just tell us what they think should be the right policy in any given case. I mean, why have the laws written down at all if the words are not going to hold the meaning they had at the time? I mean, the point here, Tony, is that the Supreme Court, the majority, admits that the way they're reinterpreting the statute is not what an ordinary person who would have heard this in 1964, would have read those words in 1964, they wouldn't have ever thought that the meaning of the statute was what the court says it is today. Well, that should be the end of the inquiry right there. I mean, that's what originalist textualism is. Now, I want to add a caveat here, similar to yours, in that, Justice Gorsuch, who wrote the opinion here, this is not a personal critique on my part of Justice Gorsuch. I don't really know him personally, but he's clearly a very able jurist. I think he did this in with all good faith, and it's a very able opinion. I mean, this isn't a stupid opinion. The problem with it is not that it's badly reasoned; it's that it's wrongly reasoned. So I question not not him personally, but how we got here. How is it that all of our defense of textualism and originalism gets us to a point where somebody uses those words and those terms, but to reach a result, as you just said, that actually has almost nothing to do with the text?
I don't know if it's just me, but it seems a bit ironic that in the opinion they tried to defend this opinion in line with textualism, but they redefined the word sex. So how can I trust them to actually have the right definition of textualism?
Well, exactly. I mean, this is just a case where the court is substituting its own judgment, and that is against the Article III power, contrary to the charge that they were given. And for religious conservatives, Tony, I think bottom line is we've got to stand up and say we're not going to take this anymore.
Well, Senator Josh Hawley, we're grateful for you standing up on Capitol Hill, consistently raising these issues. Thanks so much for joining us today on Washington Watch.
Thanks for having me. Thank you.